it's still important to have your non-competes, and this only applies to the states who actually allow non-competes, but it's important to have your non-competes tailored to your state's laws.
Welcome to the American Med Spa Association podcast, Medical Spa Insider. This week, AmSpa founder Alex Thiersch is speaking with Patrick O'Brien, JD, of AmSpa and ByrdAdatto, and Grace Lee, associate with the law firm ByrdAdatto.
All right, everybody, welcome. This is Alex Thiersch, and this is Medical Spa Insider. Thank you to all of you who are listening, and those of you who are watching on YouTube. Thank you, I think. That always makes us a little bit nervous because we don't like to be, we're used to being kind of behind the scenes, and here we are now. Everyone's seeing our faces. Maybe we haven't decided if we're going to launch this on video yet. Now I'm making everybody nervous by talking like this. See, this is my problem, Grace. We were talking about ahead of time. I just start to babble, and next thing you know, it's an hour. So, but anyway, I wanted to welcome everybody. Recently, just last week. So we're at the end of April right now, and last week the FTC announced a rule on non-compete clauses, and I'm sure many of you, if not all of you, have heard that, but this is something that has been coming, and we've known that there was going to be some sort of a rule, but this came down, and it really was probably as restrictive or more restrictive as they could get, but the rule basically bans the use of non-competes in employments and contracts. And things like that. So, and that is obviously a big deal for all industries. It is a particularly a big deal in high skilled industries, and certainly healthcare, and certainly aesthetics and medical spas is one of those. We have obviously very highly trained folks who are involved in what we're doing, and the use of non-competes in our industry is, I wouldn't say it's pervasive, but it is common, or at least not uncommon. A lot of folks are concerned about what happens if you train up an employee, like a nurse injector, let's say, or someone else, and then they are able to basically leave your med spa and go down the street, open their own, and therefore obviously have an impact on your business. And so we're here to discuss all that, discuss the new rules, get into a little bit of the nuances of what's going on and how it might affect you. To do this, we have two very, very talented and smart attorneys. So you've got three attorneys for the price of one on the AmSpa hotline now. Patrick O'Brien, who is the general counsel and a very smart lawyer down in Dallas, who works for AmSpa, general counsel for AmSpa, and Grace Lee, who is a lawyer for ByrdAdatto, both of whom wrote fairly extensive blog articles on this new rule, which we have the one that Patrick wrote on our website, and then we'll try to figure out how to link to yours too, Grace, so you can see it. But both of you, welcome to the program. We don't want to bore folks too much with non-competes, so we'll try to keep this short and sweet. But this is an important issue. And Patrick, I know you've been looking at this for a while. This is something we've been dealing with off and on, because non-competes, again, I get a lot of questions about those whenever I speak. But Patrick, if you could, please go through just kind of high level what this rule is, what it does, and just kind of what your overall thoughts on that, if you have any.
Sure. So this is, as Alex said, this is the final rule. They've been working on this for a little while, and it broadly bans non-competes. There's definitions in the rule for everything, and they're written very generally. But so by non-compete, they mean anything that penalizes or keeps a worker from seeking other employment or starting their own business after they leave employment. That's the general thing, and it will be prohibited once the rule goes into effect. Not only does it prohibit new ones from being entered, but if you're currently have a contractual non-compete, those won't be enforceable after the rule goes into effect, with one exception that I'm sure we'll pick apart in a bit here for executive employees. The businesses also have a duty to notify current and past employees about the inapplicability of these non-competes now. So if you have someone who quit, who's subject to one, and now under the rule they're not going to, then you'll need to send a a message to them saying that it's no longer effective. That's the kind of the high level of it. There's tons of details we can get into.
Yeah, for sure. So it's and obviously for those, I guess maybe we should take a step back even, and because there are a lot of folks who are new to business and new to the industry who are listening, and obviously non-competes our ability to prevent folks from competing with a particular business. So if you are an employer, or if you're a contract or an employee, I should say, or a contractor, and then you leave, non-competes restrict your ability to compete with your former employer. So you usually the way it's drafted is you're not able to actually get employed by somebody within a particular area that is surrounding that business for a number of months or years, depending on how they do it. They can be very, very oppressive. In times we've seen some of these where they try to restrict folks from being able to work in their particular industry for years and years, and that can be tough. But so that's the general rule. If Grace, and I know you've got a bunch of knowledge on this, let's start going through. First of all, the first question I had was who is kind of subject to this? It seems to me that there are there may be certain exceptions for certain types of people, certain types of workers. But let's get into kind of what the exceptions are to this. So we know that the general rule is non-competes are going to be banned. You have a duty to tell people that they're banned. You have a duty to tell people that they're no longer enforceable. Let's get into a little bit of the details and go like who is actually subject, what types of workers are subject to the final rule, and then we'll get into the exceptions.
Sure. So with regards to this final rule, workers is defined so broadly, it captures everybody, paid, unpaid. So not only like normal, regular employees, but also independent contractors are included, interns, externs, just across the board, all like categorically it's being banned for everyone, except you mentioned that exception, both you and Patrick, but the exception is for senior executives. And it's not just the title senior executives. There's actually more that goes into it. First thing you have to check is like their salary. So there's a specific monetary cap that the FTC specified, and it was like 151,000.
Yeah,
Let me look at it.
151,164.
Yeah, on an annualized. Like so, in the preceding year, if that senior executive made that much, it checks the mark for the first one. And then you move on to whether that senior executive was an officer, like a CEO or a CFO, or some sort of like managerial, authority, someone who has final authority to make those final policy decisions in a business that would actually have a substantive like impact in that business. So it's a two-pronged sort of test, but that is the only exception with regards to workers who, and it's actually, it's only for the existing non-competes. So even with these senior executives, like starting on that effective date, it's gonna, they're subject to it too. You can't enter into non-competes with them either.
So the exception for senior executives, and I want to get into that a little bit because there's some interesting questions that come into MedSpas with that. That is only for currently employed senior executives, not new ones. And when does the rule? I should have said this earlier. When does the rule go into effect? Should people be worried about this right now, or is there some time before this actually starts to happen?
So we don't need to worry about it right now. It's not in effect yet. The FTC provided 120 days after it gets published in the Federal Register, and it's not published yet. Right now, there's an ongoing litigation lawsuit trying to overturn this final rule. So we're just going to have to wait and see as to how those lawsuits turn out.
Yeah, and Patrick, assuming the pending litigation that Grace mentioned doesn't have any impact on it, let's say it doesn't stop it. How do you have any idea how long it'll take for this to be published and then go into effect? Do you have any guesses?
I don't know that it'll be very long. The Register publishes daily, Monday through Friday, so it could be as early as 120 days from tomorrow. But okay. It took the FTC a whole year to develop this rule, so there may be several weeks or months in between them voting to approve and running through all of the their internal processes to get it over to the register to be published. There's just we don't really know.
Right.
So
Right.
it could be now, could be a while from now.
Right. Makes sense. So, all right, I do want to jump into the executive policy making senior executive exception, because I think there are some circumstances in our business where this will be applicable, and some instances where I think it might be a little fuzzy. And specifically, one of the things that Grace, you mentioned was, policy making. They if they are an officer, that certainly cuts in favor of them being an exception, but none of these are requirements. It's all kind of like part of the test. Any ideas as to really what that means as far as policy making? Do you have to be in charge of the whole thing, or is this something where you can just be somewhat involved? And what I'm getting at is, in our context, we have a lot of medical directors. We have we have with MSOs and kind of the larger holding companies that have people that are all up and down the chain. And I'm trying to figure out kind of where this might fit into that. And I'm not going to hold you to the answer, but I'm curious what your thoughts are.
So there is an actual exception in that as well, as in like if this person is like in a consulting role who just merely just influences like some sort of policy-making decision, they don't count. They're not subject to it. It's really the people who are at the top who make the policies and procedures that all the staff has to like follow. Anything that actually substantively like impacts the business as a whole. So even if you are like a business enterprise where there's multiple like subsidiaries and everything, if your decision affects only like one, right, of that subsidiary, like you're not subject to it. But if you're at the top, like the parent company, and you're making these policies that affect all the employees like in a waterfall effect, then yes, you would be subject to it.
Gotcha. And it is subject to independent contractors as well. And Grace mentioned this exception about potential consultants who have influence. Obviously, you're not trying to necessarily wrap them in, but Patrick, for someone like a medical director who, and this is where my head immediately went for these things. When you have a physician who is a medical director, maybe they are making this much money, they're meeting that criteria. That's where folks tend to get a little bit nervous. What are your thoughts? And I'd love to hear both of your thoughts. I mean, is this the kind of thing where if a medical director meets that threshold for a particular med spa, do you think folks will be able to lock them up with the exception? And we'll get to some other things down the road, but with that initial senior executive exception, is that something that folks should be worried about or potentially look at with their own practice?
Well, I think it's going to depend on the specific business, on what the medical director actually does.
Right.
In states that have an MSO, we're going to get real in the weeds here, but where the medical practice needs to have a professional medical physician owner or something like that, then I think definitely the person that's in that role of medical director will have because they'll also be an owner, which is another exception that we'll discuss as well. We'll probably be in that type of position. But if it's much more of a kind of an outside advisory where they maybe set things, but the internal workings of the business still have them getting approved by someone inside the business who's not necessarily have that medical director title, then they may not. It's just really going to depend on what their roles are. It's not since medical director is not a executive title listed in the rule, it's going to be purely based on what their duties and responsibilities are.
Right. And I guess that's a good distinction to make. It's, policy with respect to the entire company, not necessarily with respect to treatment of a particular patient. Right. And that's interesting though. I mean, I know that there was some discussion about healthcare being exempted from this. Ultimately, it was ended up being included. It's interesting, I think, how they included externs, interns, volunteers. I mean, they basically tried to throw everybody in there and say, these things are not going to be allowed, basically full stop, with certain very, 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 very minor exceptions. And so I think the way that folks need to approach this, and again, Grace, tell me if you disagree, but like if you have a client that is in this case and calls for an opinion, I mean, my view to them is pretty much you should assume that folks are subject to this and they can't be under non-competes. I think it's going to be pretty difficult to get folks into any of these exceptions with the potential exception of an owner, which we'll get to in a second. But I mean, that seems to be the way this is all drafted, right? This is just kind of, they want to throw everybody in this and make sure that there's no one that's kind of slipping through. Is that your impression as well?
As of right now, I'm telling my clients to just kind of put a pause. Don't rush into making any changes or giving any notices just yet, just because we really don't know what the outcome is going to be with these lawsuits. But it's still important to have your non-competes, and this only applies to the states who actually allow non-competes. But it's important to have your non-competes tailored to your state's laws, and just make sure that they are, and any new employment agreements that you're going into right now, continue to make sure that they are being tailored to your state's laws. As for this final rule, I've just been telling them, let's see. Let's just wait and just monitor it as everything develops. We'll see.
Well, so it's a good question. Like if someone comes in, and I'd love both of your thoughts on this. If someone comes in right now and says, hey, we just hired somebody, our typical contract, whether it's an employment contract or independent contract, has a non-compete clause in it. Do we suggest they keep it in for now, or do you take it out? What Grace, what do you think?
I would suggest to actually keep it in if it's actually beneficial for their business for right now. Because honestly, even if this final rule, it goes into effect, the only thing you have to do is give them notice. You don't need to go back into your employment agreements and like amend it and take it out or change it or anything like that. You just need to give them notice saying, hey, it's not actually effective anymore. So, I mean, it's pretty easy administratively. So I would say as for right now, business as usual.
Okay. And would the same apply, Patrick, in your view to if it's a nurse injector or something who wants to get hired and what would we tell them if the employer says, here's a contract, it's going to have a non-compete? And I think, I obviously this is all subject to change, but with these type of clauses, what I've seen, and the thing that has always bothered me about them is not so much that they're in existence, but the way that they're used by some of these employers to kind of really try to chill someone's ability to do things. What advice do we have for providers out there who maybe are faced with a non-compete right now?
Yeah, so non-competes have always been a kind of, I guess, gray area. States want them to be enforced, but within kind of narrow limits that get kind of defined in court cases and in some laws, and so they want them narrowly tailored to protect the business's actual interests. They don't want them to actually keep the other person from finding gainful employment. So anything that starts to be you can't work anywhere in the U.S. is going to be frowned upon versus within a mile of the business or something like that. Very sliding scale, and you never really know ahead of time if the non-compete that you have right now is going to be enforceable. It usually takes a court case to find out if it gets upheld. With this rule, or rather, once the 120 days finally start, not really much has changed, because you will know that it still could be enforceable if the court cases come through. It maybe not. You just want to make sure that it's kind of tailored to whatever your state's laws are. But just kind of keep in mind that it may not be there if your employment ends. So as a employer, don't rely on it. As an employee, don't it's not a foregone conclusion that it'll be restricting you. It's just kind of you just don't know at this point.
Yeah, I think you're right. I think it's gonna be a long time before this thing actually takes effect. My suspicion is that there will be some the works will get gummed up enough by these lawsuits and by objections and whatnot that it'll probably take some time. One of the exceptions that I think is increasingly relevant in our business deals with the sale of a business and business owners. Grace, what does that deal with, and what's the exception there that folks who maybe are looking to sell their business or acquire a business, what is that? How does that fit into this whole issue?
Well, the good news is, this rule, the final rule, doesn't apply to the sales or the sales of business or anyone's like ownership interests. This is specifically limited. Well, I say limited, but it's specific to workers and employers in that relationship.
Well, and that was the big, when I saw that, that was the big, one of the big points of contention, because I want to say it's one of the states, I want to say California is kind of grappling with this, and we're thinking of excluding even owners or former owners. And the issue here is, if you sell a business, the folks who acquire you don't want you to then go out and just start a competing business. And so you've got obviously there's an interest in there where you are trying to be loyal to the new acquiring company. And so that really creates some stickiness because you are getting actual compensation, and there's probably a lot more at stake. I mean, I'm curious, Patrick, I'll put you on the spot a little bit here. What is going to happen with this thing? Is it going to go into effect? What's the ruling going to be? Is it going to get blocked? Are we going to be all restricted? Like what's going to happen?
So I suspect that there will be probably a stay from a court case, but in other federal rules that have kind of had stays in the last couple of years, they've been limited to the membership of the suing party. So like if the Better Business Bureau is suing to stop something, then members of them are the ones protected. And while technically that's if you're outside that, then you're still subject to the rule. It does gun up the works, and it gums up the enforcement of it.
Yeah.
So I think there will be some change, but it's not going to be exactly clear what the change is for quite a while.
Grace, what do you think?
I mean, I agree. Yeah, same thing. I honestly don't think it's not going to be anything anytime soon. It's going to be a while. Like it's just.
Yeah. And then what's I'm curious, both of you wrote a little bit about this in your blogs. Like, why is this, what was the controversy with this rule? Because when it came out, it got a lot of attention. There are a lot of folks who really believe in non-competes, a lot of folks who don't believe them, obviously. What was the controversy, Grace, that caused this to be such a big deal? And that they kind of brought us here where we are right now?
There were several arguments, actually. The first one being that the main argument, well, I say main, but like the first argument is that the FTC actually doesn't have the authority or the jurisdiction to be making such a nationwide categorical ban on all types of workers' non-competes. So that's the first argument. The FTC says that they do. As of right now, there's a lawsuit with the U.S. Chamber of Commerce. They say that they don't. That being one. Another one is that the FTC thinks that the non-competes, they do suppress, workers and like their ability to get jobs, negotiate for their compensations, extra training, whatnot. But at the other end, like small business owners, they're like, well, we need to protect our confidential information. We need some sort of mechanism to be able to enforce, like all the investments that we made into someone, like we provided specialized training for or something. So there's a lot of arguments, supporting and opposing. Obviously, like with trade associations and like businesses and stuff, they are opposing with, providers like injectors and, the nurses or just normal workers, like they are supporting. But yeah.
Sure. So, I mean, we've been going on for close to half an hour. I would love some just kind of final thoughts. I mean, we could probably, get into, my mind is already going to, okay, how are folks going to protect their interests when it comes to things like training, right? So if, let's say this does go into effect and you're training somebody to be an injector, how do you protect that investment? Because that's really where a lot of the questions that I get come from. So if you could just give me your final thoughts, and then we're going to be talking about this a lot as we go. Obviously, we'll be tracking the litigation. I happen to agree. I don't especially the way that the Supreme Court is kind of constructed right now. I don't know if it'll go that high even, but I have my doubts that this thing will ever see the light of day. That's kind of my thought. I don't know if that's true, and I don't want to make any predictions, but I would definitely tell people that there's a long way to go before this becomes actual law. It was surprising to me. I don't know how you guys feel, but it was surprising to me that a rule this broad was passed. And I think that's one of the issues that a lot of attorneys are having right now, is that the kind of the breadth of it, saying, hey, we're going to ban non-competes in all states in all cases, really it's a bit wide ranging and broad. And I think a lot of times folks don't, the courts don't want a specific, whether it's an administrative office like the FTC, or even politicians making that kind of rule. But Patrick, final thoughts on this? I'm curious what you're thinking, and then we'll sign off for the day.
Yeah, I agree that this is probably has a rough road ahead. I'd say my final thoughts are that if you are an employer and employee, you should look at what your current state's rules are and make sure that whatever contractual provisions you've got are kind of in keeping with that. Because even absent this, there's still always state rules or laws that can change. I think what Colorado was pretty recent in banning theirs. So you just want to have kind of a plan because it's not necessarily going to be this way forever. Something will change. It may not be this particular thing, but future legislation or rules may change it.
Yeah, I agree. I do think that kind of the trend is away from these. So I think a lot of states are going to move in that direction. Obviously, some won't. But Grace, how about you? Final thoughts?
Yeah, I agree with Patrick on that as well. I think as of right now, if just make sure that there are certain safeguards in place where you can have your information protected. You still have our NDAs, non-disclosure agreements and stuff. So, and there is also a controversy with that as well. Is it included in this non-compete final rule or not? But like I said, that's one of the things that we're just gonna have to wait and see. Just business as usual. Just make sure that if you're an employer, whatever non-competes that you do want to have in place, that they're reasonable. They're not in within the entire country or the entire state, but with a 1 mile marker, and it's not 50 years, but it's more 12 months or 24 months, after someone's employment ends. So just think about reasonableness, and I think you should be good to go.
Well, and a real quick follow up, because you mentioned something with not NDAs and what about non-solicitation? So that's often part of agreements where it's okay, you can't work in a mile radius, but you also can't contact current employees. Is any of that, Grace, included in all this yet, or do we not know?
So as of right now, the way the FTC defined non-compete, it's very broad. So you could arguably say that it is included. And as of right now, that lawsuit that we keep referencing, they do mention that there should be some sort of exception for NDAs, an actual specific expressed exception. But because of the way that the FTC defined non-compete, it could. It just depends.
Okay. All right. Interesting. All right. Well, we shall see. So for now, we're kind of in a holding pattern, right? I think it's important that everyone knows that this is happening, but I don't think there should be any panic. And either way, we're going to find out, some guidance on this, and we'll certainly be following up with other podcasts and other information to come in the future. Thank you so much, Patrick, Grace. I appreciate your time. This was short and sweet. We love talking about non-compete, so we're going to try to do this, at least once or twice a week going forward. And I'm joking for those of you who about drove off the road thinking that. So, but thank you both for your time. I appreciate it.
Thank you.
Yeah.
Thank you for watching the Medical Spa Insider podcast. Please make sure to subscribe to our channel for future videos and podcasts. For more information about the American Med Spa Association, please check our description below.